So one of the things that we're looking at in terms of the new UPC is who is going to be litigating there. So there's been tons of discussion around opt-in, opt-out. We know that pharma are opting out their blockbusters because massively high risk in a new system. But from your experience and from the discussions that you've had, who is going to be there on day one, taking up the court's time and shaping the jurisdiction?
Well, I think very much as perhaps was predicted, we'll see non-practicing entities. We've had very clear indications in the technology, electronics side that they are very keen to use the UPC system and litigate. On the pharma side, you're absolutely right that they are opting out blockbusters, anything that's kind of, they've got plans for loss of exclusivity, the revenues coming in. Nobody really wants to risk it at this stage, the potential to lose a patent in one go, rather than, what they would hope to see if it's kept outside the UPC. But it is actually a bit of a mixed picture. What's been quite surprising, some side where actually they're not that litigious, and people are opting out. They're being really cautious. But we also have seen on the other side, we've seen some of the chemical companies are being way more bullish about keeping the patents in the UPC and potentially using them. With standard essential patents, quite a few of the companies that we're talking to are going to keep them in. It is a really big stick to leverage in a licensing discussion if you've got the potential for a pan UPC injunction. One of the things that sort of is slightly unfortunate is that this whole system, the rationale behind it was to make patent litigation in Europe better, easier, cheaper. It was all for the SMEs who it was often felt were left out in the cold in our current system. And what we're seeing is that the SMEs are really turned off. They are opting out. They don't want to be in. They're worried about their risk, being sued within the UPC. And so right now, SMEs do not look like they're going to be benefiting from the UPC. And so really the conversations that we're having is, how critical is this particular patent portfolio to the business? Are you able to cope with a loss, a central revocation loss? And lots of people are being cautious because even if you feel you've got a strong patent, there is always a litigation risk. And there is a degree of unpredictability right now with the UPC in terms of how it will pan out with the case law. That said, so this is now, but I do think 2-3 years down the line, this will become the de facto forum for litigating in Europe. It will be a really important part of the overall litigation strategy for European patents.
You mentioned that there's a huge interest from NPEs, non-practicing entities, in the new court. Do you think that's as a standalone jurisdiction or as part of a multi-jurisdictional campaign? Because we know, the US, big market, triple damages potential, but very difficult to get an injunction. Is it a strategic interest from NPEs, or is it just because the new court will be simpler? And I guess on top of that, do you think the fact that there are adverse party costs is going to be another factor that NPEs will not be used to if they've been used to litigating in the US?
One of the reasons why we have adverse party costs in the UPC system is precisely because of the worry about non-practicing entities. And so that is, in fact, part of the overall strategy they've got to take into account. If they're not successful, then they will be looking at costs. That said, it's obviously relative to the value in dispute. And, there will become some cost shifting, but it's not quite the same as if they lost in the UK, for example, where they would be looking at quite big damages. I think in terms of the why, it is the possibility of the pan UPC, possibly wider if you look at long arm jurisdiction, the injunction. That's the really big risk that anyone who sort of says, no, we're not going to take a license, will have to weigh up. And I think that's really part of the strategic decision making. There's certainly an awful lot of movement, discussion from the judges that, they will be willing to grant an injunction. And I was at a conference a couple of weeks ago, and the question was asked to one of the new prospective judges, will it weigh on you that it's a much bigger territorial area, economic area that you'll be granting an injunction for? And they were like, no, we're here, we're looking at the legal merits. And, if whoever's coming to us has a good case, whether that's a preliminary injunction or, more likely on the final merits, then we're going to be granting that injunction. So I think if you're an MPE, you cannot ignore the fact that it will be a huge stick in your licensing negotiations if you've got the possibility of that sort of injunction. I do think we'd also be looking at layered strategies. I don't think, particularly when right now you're looking at bundles of European patents, and if they don't opt them out, they obviously have the ability to litigate either in national courts or the UPC, or depending on the way that it goes, you'll have a mix of both. You could have this sort of Swiss cheese effect where you've got a certain part of a EP bundle being litigated nationally and perhaps the rest in the UPC. So I think they will still be looking at it in the broader context. And not just because I'm a UK solicitor, but I do still think the UK as a forum that deals with these sorts of disputes really well will still remain to be, a jurisdiction that people would be wanting to come and litigate in as they do now.
You mentioned the UK and the UK sort of role now that we're not part of the UPC. And you also talked about standard essential patents and those being kept in. I guess, one of the big features of the UK has been, setting FRAND rates for global portfolios. How do you think the UK, or what part do you think the UK will play once the UPC is up and running?
So in relation to the UK court, I think one of the things we think it will be used for is almost, as you know now, with the different national patent courts, perhaps you've been sued in one jurisdiction and you immediately go to another jurisdiction to almost get like a balancing effect. And also litigants go to different forums in an ability to try and get a well-reasoned judgment from a really good, well-respected court, and then they sort of shop it around other jurisdictions. The UPC will present quite a difference in that respect, because it's going to be stocked entirely with the well-respected judges. They will be there in the UPC, and effectively the only other equivalent in terms of the quality of the proceedings and what you get out of it, your judge craft and the IP patent knowledge, is the UK. And so that's potentially the sort of litigating in both could be an important thing to be thinking about. When it comes to practitioners, obviously, beyond the EU member states that are participating in the UPC, European patent attorneys outside of the UPC countries also have the ability to grandfather in and become UPC representatives, and in any event can also be part of the litigation teams, even if they're not actually UPC representatives working with co-counsel. So I think the UK will still have quite a lot of influence on litigation and involvement on litigation that's going on in the UPC, particularly because we do quite often manage pan-European litigation, and I think that will continue. The UPC is another jurisdiction that we have to take into account. So I think the UK's involvement, directly in the litigation, will be quite strong as well.
Rachel, you mentioned that the judges are all well-respected judges, and that bodes well for the UPC as a forum. But they're going to be operating under a new sort of set of procedural rules and, in combinations that they're not familiar with from their national procedure. How do you think companies and funders can approach sort of predicting outcomes in the new court in the first couple of years?
It will be, in some respect, a brave new world. But I think the way that both the infringement, the local and the regional divisions, and also the central division for the revocation and the declaration of non-infringement, the way they've been structured is to try and balance out national leanings. There's always going to be an international judge on the panels, and in the central division, there's going to be multinational panels. And also sort of they're doing an awful lot of training for all the judges, including the ones who obviously are very familiar with patent litigation. And if you look at the list of judges that have been appointed, particularly the legally qualified judges, it is the very well-known judges from around the European national patent courts. And what's quite interesting is the way that they seem to be approaching this new system is, from my point of view, this is a toolbox of everything we would normally use, but obviously it's only parts of it are only available in some jurisdictions. And now we're going to see that very comprehensive toolbox available in a single forum. And what you can see with the judges as well, it's not just, okay, this is how I would do it if I was sitting in my national court. The various mocks that have been going on, they're learning from each other. And and it's not just, okay, what happens in Germany, let's do that. It's, okay, actually for this case, or perhaps actually thinking this is a new court, how are we going to do this really well? Can we pick the best bits? And you can see that they are doing that process. So it doesn't really answer the question in terms of predictability, but I think it does give a level of confidence that it will be well reasoned. And I expect that we will see some really, really interesting case law coming out of the UPC that will then have a much more harmonizing effect actually on the national courts than we've seen to date, where, we know that if you want to question about doctrine of equivalence in 5 countries, you've got to go and get 5 sets of law firms to tell you what each country's national law is on that. So I think we will see a harmonisation in a way that we haven't seen it before.
Thanks, Rachel. That was good. You mentioned the UPC judges are quite excited about the tools and the toys that they get to play with in the UPC. Are you excited about the UPC?
I think it's the biggest change in a generation, and we have to see it as an opportunity. It is, I truly do believe it's a really big opportunity. I think the next couple of years will be for companies that are willing to take a risk, because I think there will be an awful lot of challenges and people testing the boundaries, as litigators will do, for sure. But once we get 2-3 years out, up to 5 years, I think it will be a really successful court.
You mentioned earlier the unitary patent and interest in that. Obviously, it's quite an expensive right to obtain. Have you seen there's much interest in the unitary patent, or do you think that companies are going to continue for now with their EP national route grants?
We are seeing an awful lot of interest in the unitary patent, and it obviously depends whether you're in an industry or a company that would validate widely or not. And obviously, the pharmaceutical sector is really the industry that does validate widely, and we know they're being cautious. What's quite interesting is for those companies that perhaps validate in perhaps 10 to 15 countries, they're very keen. They are asking for quotes as to what it will save them in terms of renewal fees going forward. So they are really interested in that and looking at it as a cost saving exercise, whilst getting, they'll get 17 countries when it goes live. And then, at some point as we're going forward, the UP will cover 24 countries. And what's quite interesting, in fact, is, the vast majority of patents are only validated in a few countries, and one of them is the UK, which you won't get with the UP. The conversations we've had with clients is, perhaps they'll carry on with that strategy for the vast majority of the portfolio, but then say the business says to them, look, this portfolio is really important. This is going to be a really key product. Or we think we're going to have infringers. We've got more problems with people coming into the market, and actually we'd quite like a way to increase the range, the territorial scope of this patent. And so, maybe they do only validate in 3 countries, but actually they can see that just that little bit of incremental cost to get, they're paying for 4 countries and they will get 17, and that's worth it. And so there's an awful lot of commercial considerations coming into it, perhaps more than the litigation side of it. So yeah, we're definitely seeing people who are very keen to get UPs.
In terms of preparation, how are firms preparing for the UPC? Will there be different teams of litigators representing clients at the national level and in the UPC, or will there be one sort of team? Is it the same skill set that we're going to need in the UPC to the national level litigation?
I think the teams probably will be quite similar. The thing that will differ from our point of view, so as you know, we're a mixed firm. We're sort of patent attorneys, both in the UK and in Europe, as well as solicitors and Rechtsanwalt. And what's important from my point of view in thinking about who's the right person for the team, one of the really key things is who's the panel, what jurisdiction are we in, and do we have the capability, the knowledge of the judges in that jurisdiction, particularly in the jurisdictions where we know there's going to be 2 nationals, so Germany, France, the Netherlands and Italy. you really want local counsel knowledge about what those judges are like, how that court will be thinking. And so that, to me, if you don't have that as a firm in that particular area, or, as a client, if you're looking at which firm to choose, I think it's really important that that's been thought about, because the presentation to those judges and the knowledge of that court is going to be really important. One of the things, so I'm leading up the firm's UPC offering, and I've just had lots and lots of conversations with European patent litigators, European patent litigation firms across Europe. And what's quite interesting is, there's a huge amount of preparation gone in. A lot of the firms are quite keenly aware of the very tough deadlines within the UPC litigation, and particularly if you're on the receiving end. And so what are you seeing? You've seen quite a few firms who've been announcing kind of co-counsel offerings, but also I think people are quite interested in terms of the technical strength and depth as well. That's really, you're going to need that. You're going to need that alongside the legal. And a lot of firms don't necessarily have a huge depth for every technical capability. So it's perhaps a bit less, oh, my client's brought this in and we're going to do this litigation. It is actually properly looking at who's your full team sheet. Okay, who's the right person to pull in here? And the sort of, with the timetable, we're used to how tricky litigation deadlines can be. But I think it might be a bit of a shock in some jurisdictions where you're going from, proceedings that take 3 to 4 years to, the really, you've got to get it in, and it's obviously front loaded as well. So,
yeah, I think with the front loaded preparation and the 1 year ambitious timeline that the court has set out, that could have an impact on the kind of ability of parties to prepare. Do you think that it could be quite claimant friendly to begin with, because defendants are going to have less time to react and claimants will be fully prepared on day one when they issue their complaint?
100%. Yes. I think there is a huge advantage to being the one putting in the proceedings. And so, in the scenario where we're talking to clients about freedom to operate, or we know that perhaps they've already seen some kind of correspondence in one of the European jurisdictions, it's also thinking about, right, if the patentee that you know about doesn't opt this patent out and decides to litigate in the UPC, are we ready? And I think one of so it's the technical ability, and if you're a claimant and you've got your expert evidence ready, you've got all of that. I mean, how long it sometimes can take to find the right expert. And so that's one of the big things I think that will be the pressure will be on defendants, definitely. And we can see that the court is very keen on not extending unless there's a very good reason.
I don't know if you can answer this, but does the UPC have a protective letters procedure like Germany?
Yes, the UPC. So this will be, I think, really an important part, and is the fact that you can put in a protective letter. So, currently you talk to anyone who's sort of worried about being sued in Germany or the Netherlands or a few other places that accept them. And yes, this, obviously you put your arguments down on file. It's confidential until you get sued. And I mean, in reality, it is to stop you being injuncted on an ex parte basis, although that's probably, unless you're like a bad actor, it's pretty unlikely it would be done on an ex parte basis. But that, again, you've already put your thoughts down. You started thinking. Well, I was talking to a German litigation firm, and they were saying you do this dance where you want to put enough in the protective letter to say, call me to court, give me a chance to defend this, without kind of being so comprehensive that the court's like, well, actually, I don't need to call you in because I can see all your arguments here. So there's always that sort of dance with protective letters in any event. But yeah, it's a really important key part if you're worried about being sued.
So one area that funders are always very interested in is the economics of a case and the potential for the UPC to have a wider damages pool than national jurisdiction litigation in Europe. Do you think that in the early years there will effectively be bigger damages available, given that the patents that are going to be litigated are going to be the bundle of national patents that people have validated? Or do you think we need to wait for the unitary patent to be granted and then litigated to see the wider damages pools really come into effect?
I think it's a really good question. The two attractive elements for patentees is the injunction and then also what you can get in terms of damages. But as you pointed out, for the bundles, it depends where it's validated and how widely it's validated. And when it comes to the unitary patent, obviously, then you are looking at a much wider territorial area. We know it's the way that the damages provisions have been set up is effectively mirroring the enforcement directive, and as is the case across all of the national patent courts now. When you look at the commentary about how will damages be calculated and, what will the judgments look like, all the commentary says the UPC will have a number of different national traditions to draw on. And so everybody from, we're not going to give you too much through to, actually we're quite generous. Obviously there's no punitive damages. So there's no kind of willful element. There's nothing like that. It remains as it is currently in Europe. And another thing that the UPC will have to look at is to what extent they will award damages in relation to someone who says, well, I'm an innocent infringer. So I think there's a lot of questions that will be worked out on damages and the kind of the scope of the damages. We know the general principles as to how it will be, the things that will be on offer in terms of, reasonable royalty, accounted profits, etc. There's a very powerful opening the books procedure if you look at the damages procedure in the UPC, which I think is quite a sort of powerful tool that a patentee will be able to use if, we're assuming that they'll do the sort of substantive on the merits first and then go on to the damages procedure, although you don't actually have to do that. But, I think the potential is there to be really, really meaningful. But you're right, I think it will be a lot more likely to be significant damages once you get into UPs being litigated.
Rachel, I've heard that there's a concept of long-arm jurisdiction for the UPC, and given that the UK is no longer part of the system, what does that actually mean?
Well, Emily, that is, I think, one of the things that falls into categories of to be litigated. So what's happened is that in terms of setting up the UPC as a sort of supranational court across a number of member states, the Brussels regulation, which manages the interaction between different courts, has been amended. And what we've seen is a very express long-arm jurisdiction given to the UPC. And what that is expressly is that the UPC has jurisdiction over defendants that are domiciled outside the EU, which is referred to as third states, for infringements of European patents within the EU. And going on from that, where they've got jurisdiction over these defendants in third states, and that of course does include the UK, for example, now that we're no longer part of the EU, where there is jurisdiction in respect of European patent infringement giving rise to damages within the EU, then there is this other further long-arm jurisdiction where the UPC may, and I use the word may, exercise jurisdiction in relation to damages arising in the third state. So we're talking about damage in the UK, for example. And there's a couple of caveats on that. The defendant has to have property within the UPC countries, and there has to be this sufficient connection test with the action that's going on in the UPC states. So there are quite a few provisos, but in theory, and I heard this example given at a conference recently. For example, if you had a defendant that was headquartered in the Netherlands and had sort of multiple branches around Europe and some in UPC countries and perhaps one in the UK, can the UPC, if there's a finding of infringement, effectively say to the, stop infringing? And the way that the penalty would work is that they would be, if in the UK, the UK subsidiary continued to infringe, then they would penalise by fines the Dutch company. So that's sort of the starting point. If you were perhaps doing protective measures, preliminary infringement, for example. And with the provisional and preliminary measures, there is a sort of proviso that the UPC can enforce that, even if actually the third state, so the UK, would have the sort of jurisdiction over the substance of the matter. So the question is, what matters is, I mean, perhaps you can fine the Dutch company, but can you actually come to the UK court and say, we want you to enforce this order against a UK company and it's been made by the UPC court? And that's the bit that's really unclear. We know that the English judges are huge proponents of this system, and you can see that they want it to work. They want it to work well, but obviously, part of the reason for why the UK left the EU is to remove itself, and why we didn't proceed with the UPC is to remove itself from the jurisdiction of the Court of Justice of the European Union. So, if I was defending the person who's on the receiving end of that, you'd be going to try and get an anti-suit injunction to stop that being, made against that company. But what we don't know is how will that play out. But we do know that companies are looking at scenarios where they are potentially going to be able to look at doing this. And I think people want to test it to see where it's at. So I think we will see cases that will give us an idea about how long of a reach the long-arm jurisdiction will be in reality. Emily, from a litigation funder perspective, how attractive is the UPC for you? And are there any different considerations that you would need to see in the proposals coming to you for potential funding for UPC cases?
I think the UPC has the potential to be very attractive, but it's all going to depend on predictability and who's there and what assets are there. So the opt-out question and which patents and how broadly those patents have been validated that remain in has a direct impact on damages potential, and economic considerations as well as merits considerations are really important for litigation funders. So when we assess a case, we look at the merits, and yes, it needs to be a strong case on the merits, but we also look at, is the investment going to be economically viable? So we know that the costs of litigating in the UPC are more expensive than, for example, a German national action, and initially probably more expensive than the costs will be, after a couple of years once the system is kind of bedded down. So the damages need to be sufficient that a funding makes sense commercially for us and for the client and for the law firm. I think the interesting thing from my side about the UPC is that some countries enable, fee agreements and contingency fees, and some countries that's not permissible. So, for example, in Germany, a contingency fee is not available, and those litigators will be competing in the same court with litigators who are able to work on a contingent fee. So it's going to be interesting to see I'm going to say forum shopping of law firms to represent organisations in the new court. I think the other consideration is the adverse party cost. So obviously there are adverse party costs in some European jurisdictions. Again, Germany is a good example. They have statutory costs against a scale, and the UPC costs are also against a scale by value, but the level of cost is much higher than is generally seen in Germany. And so from our side, we want to see what kind of insurance is available in the market. At the moment, ATE or after the event insurance is very London centric. So if the case has a nexus to London, so it's a UK firm, it's a UK company litigating the litigations in the UK, the market for ATE is much broader than for cases which have no UK nexus. And because the insurance market is so London centric, some insurers now, following Brexit, don't have a license to insure in Europe. So it'll be interesting to see the development in that market to cater for these adverse party costs and the ability to mitigate the risk of those. I think the other sort of considerations for us are predictability and what are the outcomes going to look like? Is the time period really going to be a year, which is quite a short time frame, potentially plaintiff friendly, which from our side is positive because usually funding is of claimants. But can we take judge attitude and approach from their national jurisdiction and look at that in the context of the UPC? Are we going to be able to successfully sort of assess the risk of investing in the cases in the first few years, or is it going to be too high risk? So I think from our side, broader damages potential could be interesting depending on the specific case. I think the fact that some of the judges are really known entities is interesting, and the different concepts that make up the UPC are known from the different collection of jurisdictions that have inputted into the UPC agreement. But how that really plays out is definitely a question mark. And I think we're quietly excited, but also slightly terrified of an early phase investment in the UPC.